On Thursday, April 25th, the Supreme Court of the United States will hear oral arguments on whether, and if so, to what extent does a former president enjoy presidential immunity from criminal prosecution for conduct alleged to involve official acts during his tenure in office. So I have talked extensively about this, and if you go onto my channel, you will see several videos of the question presented, then of Donald's opening brief, Jack Smith's response, and Donald's reply to Jack Smith's response. I've also broken up the videos, and the last posted one was about Donald Trump's audacious argument that the actions specifically alleged in Jack Smith's indictment were all tangled up with Donald Trump's official duties, and because they were tangled up, commingled is one way of looking at it, they were official duties over which Donald Trump has absolute presidential immunity. At this point, it is absolute because under Donald Trump's argument, because the Senate did not convict him in the impeachment judgment clause forecloses any more opportunity to prosecute a former president. That's their argument, that the impeachment judgment clause says that only after Senate conviction in impeachment can a president be prosecuted. But that is the exact opposite of what Donald's attorneys argued in the second impeachment trial, that Donald Trump's fora, because he was already a former president for when the impeachment trial was happening, that first of all, that Senate didn't have the authority. 30 senators voiced concern of whether Senate had authority to impeach, to convict in the impeachment proceeding, and also the main remedy of impeachment is removal from office, and that had already happened because he had left. And thereby, the Republicans left open the avenue of him running again and the avenue of him turning around and using the opposite argument from what he argued regarding immunity beforehand, with when he wasn't part of this, he wasn't a criminal defendant. So Jack Smith alleges that Donald Trump's actions were private and the indictment alleges that they were criminal. Donald Trump argues that they were official, and in his response, in his last filing, he wrote that they were all tangled with his official duties. And because in the first part of his opening brief, he said that president's official acts may never be reviewable, that Donald Trump has absolute immunity from criminal prosecution. Jack Smith's argument, Jack Smith really went and defeated the argument that former presidents have any sort of presidential immunity. Because the question is, as presented by the Supreme Court, whether former presidents have immunity in case of acts, conduct while they were in office that allegedly involved official acts. So the Supreme Court convoluted the question, and I believe that in a way, Jack Smith answered that question first by saying that former presidents don't have the immunity that current presidents, incumbents have. The immunity doesn't travel with it. And then alternatively arguing that these were not official duties. These were not official acts. These were private acts with private people towards a private goal of grabbing power after having lost the 2020 election. Now, he employed private attorneys, Sidney Powell, Rudy Giuliani, John Eastman, to carry out these private endeavors with other members of Congress and even the vice president. Remember, John Eastman went to the vice president. It wasn't Pat Cipollone or Eric Hirschman going in the capacity of White House counsel. Donald Trump employed John Eastman, a private attorney who was Donald Trump's attorney, to go after and pressure Mike Pence. Same thing happened with the people talking to Scott Perry and other members of Congress. He was communicating and conspiring with his allies, Rudy Giuliani, Eastman, Kenneth Chesebro, to go out and talk to members of Congress. So he seldom directly talked to them, as mob bosses don't talk to people 2 or 3 steps removed from them. So, the question is, what will the Supreme Court do? And I believe that the Supreme Court is going to remand the case back to the trial court. Now, I also think that there's a chance that the Supreme Court is going to say that there is some residual criminal immunity for certain official acts, but whether those official acts are private or official has to be a determination of fact. And once that determination is made, whether the acts were official or private, by a fact-finding jury in a criminal trial, if he is convicted of the crimes, it will go to prove that he committed these crimes because they were private acts. If he is acquitted of the crimes, that he didn't commit any of these crimes, then the question of whether he has immunity or not goes away, in a sense that he doesn't have immunity doesn't necessarily mean that it would leave the question open as to whether former presidents have immunity for those particular acts. It'll foreclose that no, it doesn't have immunity for crimes. Now, whether the Supreme Court thinks that there are other circumstances in which there is immunity or not, the Supreme Court will have to take up that issue when that arises. So the real crux of the matter is for the Supreme Court to promptly return this case, and hopefully within a couple of days of oral arguments that'll happen in a few hours here, and remand the case back to trial court for determination of fact of whether those acts were whether those acts were private or whether they were official. And if there are some official channels, whether those ends were met through official channels or private channels. And then determine whether the acts, the end goal of upending the rule of law, conspiring to defraud, whether that rose to the level of something that fell within the presidential powers in Article 2 of the Constitution or not. And the answer to that is a no, it isn't. And so the trial process has to happen. And that's because the Supreme Court itself said in Barker v. Wingo that there's a societal interest in speedy trials because of recollection of witnesses may fade, because defendants out on bail may commit more crimes or, jump bail and run away, or the possibility, and then the cost on the taxpayer, because the taxpayer pays for the prosecution and the judiciary. All of these matters point to the Supreme Court promptly returning this case so the case may move forward in trial court without any further delay. It has been delayed since February 6th. So we will hear oral arguments in a few hours, and I am very eager to see what the government argues and how forcefully they argued the alternate argument that Donald Trump's acts were not official acts, they were private acts, and only a fact-finding jury, or if Donald Trump chooses a bench trial with Judge Chutkan, that's unlikely to happen, that determines the facts of the case and whether his acts were official or private. And, obviously commingling them, as Donald has done in his Mar-a-Lago case by commingling personal effects with classified documents. Here, it's commingling his official acts with the criminal acts in a way as to say, I am committing official acts, when they're the color of official act, but actually private action via private parties towards the private end of staying in power past the time that he was given, because he lost the 2020 election. And there was no evidence of election fraud, according to his people that he wanted to remove, like the Department of Justice Acting Attorney General. So let's see what the oral arguments will go. I will do my best to summarize the oral arguments. This is really big. In my mind, the criminal conspiracy trial in D.C. is the big deal case, that the real trial of the century, because it is Donald Trump defrauding the United States and depriving its citizens of our right of our vote, and obstructing congressional proceeding, the hallowed proceeding of certification of the presidential elector votes. So the electoral vote count was obstructed, and so a jury needs to hear this case. That's what the Supreme Court needs to focus on. And one of the answers to the questions that Andrew Weissman asked was, would the Supreme Court to ask probably the government's attorney, that if they wanted an expedient ruling, only if it was in their favor, or whether or not it was in their favor. And for the purpose of judicial expediency, for the purpose of the public interest in a speedy trial, the answer should be that we want an answer soon, whether or not you rule in our favor. And I believe that would be the government's answer. And I don't know how Donald's attorney is going to field that answer. So with that said, thank you for being here with me. And I will talk to you soon as the oral arguments end and I am able to process them. It's probably going to happen tomorrow. With that said, thank you so much. Take care.